Good evening. A major legal confrontation is taking shape in Washington as President Donald Trump begins his second term with a series of sweeping executive actions that are already testing the limits of presidential authority. In the first week since returning to office in January, the president has moved rapidly to implement key campaign promises through unilateral decisions, prompting a growing number of legal challenges and setting the stage for what could become a historic clash between the White House and the federal judiciary. Since assuming office, President Trump has ordered the suspension of all new asylum claims, canceled refugee resettlement programs, frozen government hiring and spending, dismantled agencies established by Congress, moved to ban gender transition care for teenagers, and offered a buyout deal to hundreds of thousands of federal workers. These actions represent a broad and aggressive use of executive power, carried out in a short period of time and largely without direct involvement from Congress. The pace and scope of these decisions have drawn immediate attention from legal experts and political observers. In response, a range of lawsuits have been filed by Democrats, labor unions, and legal advocacy groups. So far, the most significant resistance to the president's agenda has come from the federal courts. Judges have already issued temporary rulings, blocking or suspending some of the administration's most controversial measures. Despite these setbacks, the president has continued to move forward with his agenda. The situation has raised the possibility of a direct confrontation between the executive branch and the judiciary, a scenario that could ultimately place the matter before the U.S. Supreme Court. In the previous term, the Supreme Court issued a major decision holding that President Trump, along with future presidents, is largely immune from criminal prosecution for official actions taken while in office. That ruling marked a significant expansion of presidential authority. This week, a federal judge in Rhode Island stated that the Trump administration was clearly and openly defying a court order that required the unfreezing of billions of dollars in federal funds. The White House maintained that every action taken by the president was completely lawful. One of the central disputes involves the president's decision to freeze hundreds of billions of dollars in federal grants and to dismantle USAID. Critics argue that these moves directly conflict with the constitutional structure of the U.S. government, particularly the principle that Congress controls federal spending. USAID itself was established by Congress, and multiple lawsuits have been filed claiming that the president has no legal authority to dismantle the agency or to refuse to distribute funds that were already approved by legislators. At the same time, some legal scholars believe that even court defeats could serve a political purpose for the president. Ilya Shapiro has suggested that being challenged in court and losing could allow the president to campaign against judges and use those rulings as part of a broader political narrative. However, a more serious scenario has emerged. President Trump could choose to simply ignore court orders. In comments made from the Oval Office, he hinted at this possibility, questioning whether a judge should be able to prevent his efforts to eliminate corruption. These remarks were followed by statements from Vice President J.D. Vance, who wrote that judges are not allowed to control the executive branch's legitimate power. This echoed previous comments that the president should refuse to comply with orders preventing him from firing federal employees. Such statements have raised alarm among legal scholars, who warn that openly defying a federal court would represent a dramatic break from centuries of American legal tradition and amount to the early stages of a constitutional crisis. As this legal conflict continues to unfold, it raises fundamental questions about the balance of power. That historical dimension and its relevance to the current situation will be discussed in Part 2. As the legal disputes surrounding President Donald Trump's executive actions continue to expand, attention has increasingly shifted toward how the administration is responding to judicial resistance and what that response reveals about the broader direction of executive power in the United States. The administration's handling of the Rhode Island court ruling has become one of the most prominent examples of this emerging conflict. In that case, a federal judge had issued a temporary restraining order blocking the president's directive to freeze certain categories of federal spending. The judge described the administration's actions as clearly and openly defiant, signaling an unusually strong rebuke from the bench. However, while the judge issued a warning, he stopped short of holding the administration in contempt of court. In response to the judge's comments, the White House stated that every action taken by President Trump was completely lawful. This firm stance has been echoed by senior administration officials who who have repeatedly defended the president's executive authority. At the center of several lawsuits is the president's decision to freeze hundreds of billions of dollars in federal grants and dismantle USAID. These actions have triggered a series of legal arguments centered on the separation of powers and the constitutional role of Congress, which holds the exclusive authority to control federal spending. This authority is commonly referred to as the power of the purse, and it serves as one of the primary mechanisms by which the legislative branch checks the executive. Lawsuits argue that the president lacks the legal authority to dismantle an agency established by Congress or to withhold funds lawmakers have already approved. Legal experts say these disputes go beyond individual policies and instead strike at the foundation of how power is divided within the federal government. If courts ultimately rule in favor of the president, it could establish a precedent that allows future administrations to bypass Congress on major spending decisions. The potential involvement of the U.S. Supreme Court adds another layer of complexity. The current court has a conservative majority, including 3 appointed by President Trump. In the previous term, the court issued a landmark decision holding that presidents are largely immune from criminal prosecution for official acts. Some legal scholars suggest that court challenges may serve a political purpose for the president. Experts argue that being challenged in court and even losing could allow the president to campaign against judges and portray himself as being blocked by the legal system. However, the situation becomes far more serious if the administration moves beyond criticism and into outright defiance of court orders. President Trump's comments from the Oval Office were interpreted by many as a signal that such a path remains under consideration. Vice President J.D. Vance later made the administration's position even clearer, writing that judges are not allowed to control the executive branch's legitimate power. This reflected a view that the courts should not interfere with what the administration considers to be lawful executive actions. Defying a federal court order would represent a fundamental departure from the norms that have governed American constitutional practice for centuries. Ignoring court rulings would effectively undermine the judiciary's role and destabilize the system of checks and balances. Fred Smith, a professor at Emory University School of Law, stated that the administration is doing many things that are clearly against the law, along with some actions that fall closer to legal limits, breaking established norms. Despite the rhetoric, the administration has not yet been formally sanctioned for disobeying a court order. In the Rhode Island case, the judge warned that the administration was violating his order but chose not to hold officials in contempt. Conservative legal scholar Ed Whelan described the idea of defying a court order as extremely grave. He emphasized that the U.S. constitutional system is built on a strong presumption that the executive branch will comply with federal court rulings. As the confrontation continues, legal analysts warn that the consequences could extend far beyond the current administration. The focus is now on the potential risks to the rule of law itself.